followed by the presentation is going to be in Chatham House rules. So we are going to keep it within this group. We can so that the conversation can happen more freely. So this conversation is recorded, and I'd like to give it over to Sajai to take it over from here, and happy to discuss this after the presentation is over. Thank you.
Thank you, Aditya. Thank you, Jay. Thank you, USIBC, for having me do this presentation today. A very topical and a very important conversation to have. And I'm glad that we are having that today. The way that I thought I would break it up would be to explain to you what the intermediary guidelines were, which came out in February, of course. They're relevant today because June was the month when most of them or all of the provisions of the guidelines became fully applicable. Obviously, 25th May was the due date for compliance. However, there were some extensions till June 10th, and I will therefore that's the reason I feel it's important for us to understand what the rules were and then come to what the clarifications from MIB were, because you would only be able to appreciate what MIB is saying if you have a background of the rules. I won't take too long, and most of you are familiar, so it will be a refresh of what we believe is new wine in a new bottle. And these were the guidelines that came about. They were guidelines for the intermediaries. However, the digital media got an ethics code. Much debate on whether digital media was covered under the IT Act, the Information Technology Act of 2000, under Section 87, these guidelines came about. We won't discuss that, but do want to give it some level of context. Why the MIB? Again, as you all probably will know, the Allocation of Business Rules 1961 allows or brings under the purview of the MIB digital media, news, and online curated content. So this is the reason why what we are discussing today, our ministry is the Ministry of Information Broadcasting, and out of the Information Technology Guidelines for Intermediaries and Digital Media Ethics Code, we are really looking at the latter part. These rules, there was a background. The previous rules had lived their life about 10 years. And they needed to be replaced because technology had changed, media had changed, and there was a lot of fake news, sexually explicit content. So there was a background for this. In terms of bringing about the rules, this was probably the right time. COVID had hit, and our dependence on social media and OTT platforms for consumption of news, entertainment, and communication had increased to a very, very high level. I will just end the slide by saying these rules were really brought about to bring a sense of accountability and responsibility for both the publisher and the intermediary. Now, the intermediary obligations, won't read them through, but there were several aspects of the intermediary obligations that came about. Some obligations may be specific to significant social media intermediaries, but the main, key objectives were to maintain records, to keep information, to keep the government updated, to take down prohibited content, and a grievance redressal methodology and system that had been put in place. Now, for news and current affairs, we had the publishers who, again, there's much debate whether publishers are intermediaries, but we leave, again, as I said, that debate out. The publishers of news and current affairs were the ones that got covered by this the section on the publishers and the OTT guidelines. Again, there was a requirement very similar to keep certain information updated, terms and conditions updated on the website, and also provide methodology for grievance redressal. Some definitions. News and current affairs, pretty straightforward, so I won't debate on that or discuss that too much. You're probably all aware. I will talk a little bit about online curated content because this is relevant when we come to the MIB clarification. Now, online curated content includes all curated content like films, audiovisual programs, documentaries, television programs, everything, but excludes, and this is very critical, news and current affairs content. Please do remember this as we move on to the MIB clarifications. The digital media definitions, again, relevant to MIB. There's a definition of news and current affairs content publisher. And this publisher included an online paper, everything. But they excluded print media, such as newspapers and replicas of e-papers, and individuals publishing such content pursuant to non-commercial activities. So where you did a replica e-paper, which is very common, we used to call it a facsimile paper many years ago, which was really printed and shared in India, where foreign papers were not allowed to be published in India, and that was a facsimile publication. So a similar thing, it's exactly the replica of the e-paper. So that's the relevant definition here. Moving on, certain other definitions. News aggregator is somebody who aggregates, curates, and presents news and current affairs content. He's probably not the publisher, but collects information from other people who are publishing. With this, I think with these definitions, these were the relevant ones. Let's get into what was really required. The most important aspect, and I'm running through all of these because these are just as a background, because we will focus on the MIB order. The focus was on a code of ethics, and I will use the term self-regulatory here because the MIB has re-emphasized that several times in the order. This is really a code of ethics which is to be followed, very similar to several other codes of ethics available to television. Television, when I mention, it's more video, the cable television that we are used to seeing, and print media. So it's a code of ethics that is by which you regulate yourself. The adherence to this, there's a code of ethics that's provided. I'll highlight some of the points in a later slide. But these you have to be adopted by the publisher, and these the publisher would then try and follow them to the best of their ability. These become relevant for when I discuss the first stage of a grievance redressal mechanism. It's a 3-stage process. So when we discuss that, please do remember that this is a code of ethics. These are to be adopted by the publisher and then implemented through when the grievance redressal mechanism is discussed by the grievance officer, by the internal mechanism to redress grievances. The other compliance that was expected was of the norms of journalistic conduct issued by the Press Council of India. This is also important. And again, this is something that print journalists are already subject to. This was extended to digital media. Then came a classification of content, curated content. We don't have a certification body here. So again, self-certification. If you're putting up content, you've curated some content and putting it up for public consumption. Again, there's a lot of debate whether it's public consumption or no, or public exhibition as we understand it under the censorship rules, but we'll again leave that point aside. When you put content out on an online platform, you need to categorize the content and you classify the content based on the target audience, based on age, and then make sure that A content through various access control mechanism is not available to children. There is, and this is what probably rattled everyone, the last point, which is that the MIB asked people to, or publishers to provide some information. This information provision may have been construed as a process of registration or a license Raj extension, and that sort of got people excited, and there were a lot of representations made. However, all that MIB was saying was provide us some basic information, can take you through that information, provide us some basic information on yourself, on your entity in India, and keep records and publish them on a monthly basis. Now, on the code of ethics, I've already mentioned the norms of journalistic conduct. The second aspect, if you were somebody who was putting up content on digital media, then the program code as available under the cable television networks would need to be adhered to. And finally, not to publish any or transmit any content which was prohibited by law. All aspects of what I've just discussed have been mentioned here, and the deck will be available, so I won't take you through all the requirements for publishers, except to state, because this comes back at another point, that before you host any content, there are certain things to be careful about, and 4 things are mentioned. 1, does that content affect the sovereignty and integrity of India, threaten or endanger or jeopardize the security of the state? Next, is it detrimental to India's friendly relations with foreign countries? And third, 3 points, and likely to incite violence or disturb the maintenance of public order. Now, these you will find in similar fashion in several other censorship and other guidelines. So this finds its way into the code of ethics. Again, the platform has to take a call, has to review the content and make sure that there's nothing which would be violative of this provision. And if so, then not put up the content or edit it appropriately. Then there is, as I mentioned, a 3-tier grievance redressal framework. Now, I'll break it down so that you understand when we read the MIB guidelines, you'll understand the impact and the fact that, and you can take a call whether it's onerous or no. So there are 3 levels. The first level is internal, totally internal. The publisher has a process. He has a grievance officer who looks at grievances and addresses them. That's the first stage. Nobody gets involved in that. It is purely the platform, the publisher. And again, what it is doing is it's using the code of ethics and internally analyzing whether the grievance is valid under the code of ethics and takes appropriate action. The second level, which is again, it's self-regulatory, only it goes beyond the publisher, it goes more industry-wide. So it's a group, or it's all industry, which is a self-regulated body, which industry experts put together, and a publisher has to be a part of one of the stakeholders of creating the self-regulatory body. And this body then looks at grievances that may not get addressed at the first level. Again, the government is not really involved here. And though there is a whole concept of registering with the MIB, it's just, again, information purposes. The MIB just wants to know that you've set it up and it's acting according to its charter. It's not doing anything wrong. MIB is not really involved in the day-to-day running or in any way involved with this second level of grievance redressal either. Then we come to the third level, where MIB establishes what is called a departmental committee, which, and I've listed the ministries who would be represented in this committee, which examines grievances and issues recommendations to the MIB. Now, it doesn't really pass any direction or order against any publisher. That's the MIB's. MIB would do that. But it's sort of the pyramid, the top of the pyramid in the grievance redressal framework. So that's to give you perspective, because this also has been addressed in in the issues raised by several stakeholders. Now, these are just the stages of grievance redressal. I won't take you through all of these, but just to say that there may be an emergency situation where the authorized officer, who I'll talk about in a minute, or the authorized officer is the Joint Secretary PNA of the MIB. The authorized officer may review content and determine that it violates all the points that I just mentioned a little while back, and may make recommendations to the MIB for removal of that content. But that's really an emergency where a delay is unacceptable. Again, the MIB would act under Section 69A, which already provides for blocking of content, and that content will be blocked. There would be no opportunity of being heard. So that's a very rare situation, but otherwise, the process that I just described, the grievance moves up the pyramid. There are certain other requirements to disclose all the grievances, to maintain records, but these are administrative. I won't take you through that. Now, a lot of on these rules for digital media, for the code of ethics, a lot of issues were raised which went up to the MIB. And then the MIB responded. It said that it is not new wine in a new bottle, it's old wine in a new bottle. Why are you getting so agitated? And on May 26, which is the first time, the MIB clarified that there is no need for registration. It's being understood as a license. It's not that. It's just some information that is required to be given to the MIB. And there are separate forms, a form for digital newspapers, which also publish and telecast news on traditional media, a form for other digital news publishers, and a form for publishers of OTT content, of online curated content, OTT platforms. So it's that's all. And what does this form say? And if you read it, it's a one-pager. It's very, very basic information, entity information. What is the contact in India? Everybody, the MIB does need a contact in India. And this, as you can see, is a trend that has started. Now the new e-commerce guidelines have been issued for public comment, which you have till July 5th to give public comment. And you'll find again that there is this need to have an India presence. And we can discuss this in another session, Jay. Won't take you through that, because otherwise the enforcement of an order becomes a huge challenge for the government of India. There is a grievance officer requirement, which is again going to be, it's come in the e-commerce guidelines as well and will come in other regulations, because the government needs a point of contact. And all they were doing was, it was just, all this information was just what Rule 18 had provided, and the MIB had just put it down in a form and asked for this information. So the MIB said, we are not asking for anything dramatic. Why do you have all these issues? So what are these issues? The first issue is that a digital arm of traditional media compliance, when extended to the digital arm, traditional media said, we are already complying with everything that you wanted us to do. We have the same or common newsroom for print, TV, and digital journalists. The content is pretty much the same, and we follow the norms of journalistic conduct, the program and advertising codes under the cable television regulations, and everything that is required to be followed. And the newspaper, the website is just an extension of the newspaper, except that its frequency is a little bit more. And content posted on a digital platform may actually just be what is already been shown on a television broadcast. So why these additional compliances for our digital arm? So the MIB examined all this, and I've listed out all the laws it examined, and you can see there are a plethora of laws. And what it said, I'll come to what it said, but all it was trying to say was that while, yes, you are doing all of this, digital media per se, because when these laws were written, all these several laws, digital media really didn't exist. And therefore, it couldn't have been included in any of these laws. So what we are doing is just making sure that these laws also cover digital media. And if you are already complying with these laws, if you are already complying with the cable television network laws, the norms of journalistic conduct, then there shouldn't be any problem for you to say that you are complying. And since it's the common newsroom, since you're same journalists, it's not onerous. It's just there were 3 people who are working in this space, 10 people working in another. Now all 13 are covered by this. So it's really nothing more is being asked to be done. And therefore, what it did mention in the order is that if we get to know, and the form also is clear, if we get to know that you are a digital arm of traditional media, we have kept and we promise to keep the information being sought to the bare minimum. And literally, if you see the forms, you'll realize the information is really bare minimum that they are seeking. The next point, what was the next issue with digital media? They spoke about Newsfeed on an OTT platform. So the OTT platform is not in the news and current affairs space. It's an OTT platform, and it has a ticker or it has a news feed. Now, the issue that came up was they said that if you have a news feed and we carry the news feed, we will become carriers of news and current affairs, and therefore we require additional compliance under the rules. So the MIB clarified that the definition, which I showed you right in the beginning, the definition of online curated content specifically excludes news and current affairs content. And therefore, if the news feed is coming on the OTT platform, it's outside the regulatory responsibility of the platform. However, if the platform receives a grievance for such content, it must or it should transmit it to the publisher of such content. So it addressed this issue of the news feed on an OTT platform. Then the next point that was raised was with regard to excessive government control. And several issues were pointed out here. I'll just raise some of the key ones. The emergency powers, which I spoke about, where, if there's an emergency where you cannot wait, you could act, or the MIB could act, or the authorized officer could act. The oversight mechanism, which was the third tier, the level 3, via the interdepartmental committee. And the final one is the registration of the self-regulatory body with the government. Now, all of these I did discuss when we were talking about them, but we'll go into slight more detail with regard to how the MIB has clarified these in the order. They are saying, and this addresses a very important issue as well. There's a whole debate which no court has actually opined on, whether these digital media, coverage of digital media by under the IT Act, where the IT Act doesn't actually cover it in many ways, is constitutional or no. No court has given an order. And by way of this particular this order that the MIB has brought about, it has clearly said that we have acted under the IT Act. So, in a manner of speaking, said that we are covered and digital media is covered. Now, we can wait for the court orders to analyze it, but as of now, OTT platforms, online curated content platforms, newsfeed, and publishers, aggregators are all covered. They talk about the three-tier dispute resolution process and mention that everything is within the control of either the publisher or the body of publishers, the group of publishers who sets up the self-regulatory body. And the self-regulatory body is registering. That's all. It's just providing information which is then makes it a body that MIB knows exists and MIB knows is covering this particular group of publishers. That's all. MIB is doing nothing with the body. So it's just information purposes. In terms of the level, the oversight mechanism, MIB's point was very, very interesting, and it said that from 2005, for television channels, we have what is called the Interministerial Committee, which is the IMC, and it's been looking into violations of the program code since 2005. It's functioned fine. No one has had an issue. So why are you assuming there will be an issue in this level 3 or oversight mechanism? In any case, the committee will be constituted by government officials and domain experts, and will be handling, everything will be handled at level 1 and 2. It's only the residual grievances that will be taken up by this committee. So it doesn't seem onerous, and there is a precedent for television channels. On the emergency powers, it directed the attention of Rule 16, which does provide emergency powers taken from the IT Act. So these were the responses that the government gave or the MIB gave. So therefore, where are we? As we speak, everyone needs to comply with the regulations, with the rules. There's been no leeway given. The only leeway the ministries gave was to traditional media which have a digital arm, saying that they will go easy. They will ask for minimal requirements for minimal information. So therefore, everyone needs to submit information in the requisite form, appoint a grievance officer, and place all relevant details as per the rules in the public domain. There's one more point that the MIB made on the excessive government control, and said that many people have said that there is the whole process is excessive and you're asking for too much information, but there's a whole body of publishers and various people who are digital media has already submitted the forms. So why is it that only a few people are getting very agitated while several have already complied with it? And also in terms of the grievance redressal mechanism and the timelines for grievance redressal, it didn't seem, there's a 15-day period given, it didn't seem like the 15-day period was overly onerous. And they said that it doesn't seem like anyone has come up and given us an alternate that this should be the structure for grievance redressal. So unless somebody comes up and gives us a structure which they feel is appropriate, we don't see any reason why this time period that we've given is inappropriate. So that's where we are. And as I'm happy to have a discussion or be a part of the discussion today, but these are my coordinates. If you would like to write to me or have a conversation separately, happy to do that. With that, I hand it back to Aditya to take it forward.